Okay, folks, we're going to get started here again. And I think Bob Grant set you up here with high expectations, okay, for this discussion, okay? So it's now my pleasure to introduce Bob Litt, the moderator for our first panel, Do We Need a Digital Geneva Convention? Bob, former General Counsel for the Director of National Intelligence, is of counsel in Morrison and Foerster's National Security and Global Risk and Crisis Management practices. He advises organizations on sensitive national security and privacy issues, white-collar investigation, and government enforcement action. Bob has a strong understanding of the IC and its equities, and we are pleased that he's going to introduce our panel and join us today. So, Bob, over to you.
Thanks, Chuck. Let's try that a little more quietly. Thank you, Chuck. It's a great privilege to be here to moderate this panel. We have 4 fabulous panelists here, and my job is mostly going to be to stay out of their way. And also, just to warn you, I have told them all that I'm going to be enforcing time limits on them for the purpose of keeping the discussion going and leaving time for questions at the end. So don't think me rude, or you can think me rude if you want, if I cut somebody off and say you have gone over time. Seated immediately to my left is Colonel Gary Korn, who is the Staff Judge Advocate at U.S. Cyber Command. Previously, he had senior legal positions in the Joint Staff, the Army Staff, and for Combined Forces Command in Afghanistan. Next to him is Dr. Catherine Lotrionte, who is the Brent Scowcroft Scholar at the Atlantic Council. She's also the founder and former director of the Cyber Project at Georgetown University, where she's taught and written on national security law, international affairs, and technology. She has served in the past as counsel to the President's Foreign Intelligence Advisory Board and Assistant General Counsel at the CIA. Angela McKay is the Senior Director of Cybersecurity Policy and Strategy within Consumer Security and Trust at Microsoft. She leads the company's public policy work on cybersecurity and cloud security, and she helps drive Microsoft's efforts to ensure a peaceful and stable cyberspace, which is going to be a principal focus of our discussion today. And finally, at the far end, appropriately, is Stewart Baker, who many of you know. He's a partner at Steptoe & Johnson. His practice covers national security, electronic surveillance, law enforcement, export control, encryption, and related technology issues. He served in the past as General Counsel of the National Security Agency and Assistant Secretary for Policy at DHS. And if you didn't notice, he had a little supplemental name tag that said at the bottom, Troublemaker, which is Stewart's institutional role. So the topic for this panel is whether we need a digital Geneva Convention. And I thought I would start by reading from this morning's Washington Post. On the federal page, there's an article that begins, "A cyber arms race is underway, and few Americans have noticed." Lisa Monaco, who served as the Homeland Security Advisor in President Barack Obama's White House, said many countries are changing how they approach the digital battlefield, from focusing primarily on espionage to geopolitical one-upmanship. Quote, "The game is getting disrupted," she said. "If we had had this conversation 2.5 years ago, I would have described the threat I was seeing at the time as more diffuse, more sophisticated, and more dangerous than at any other time in my career in government. Today, I have an overwhelming sense that if we look at the threat actors as basically aligned in a drag race, nation states, non-state actors, hacktivists, criminal groups, the nation states have far and away set themselves apart." Monaco pointed to recent reporting about Vietnam targeting multinational automotive companies, possibly for the benefit of its domestic auto industry. She said Americans need to impose high costs on bad actors and to isolate them. Quote, "We should not be naive about how difficult deterrence is in cyberspace," she said, "but we're not practicing it enough." So that sort of sets up the framework for the discussion, and I'd like to start by asking Catherine to give a little background about the history of efforts to try to achieve some kind of international rules governing cyberspace.
Sure, thank you. Thanks, Bob. Thank you for having me here today and for having us put together this panel. I'm looking forward to the questions and answers as well that we'll hopefully have lots of time for. But a little bit of background. Bob has asked me to kind of set the landscape out for just about when governments began to discuss the possibility of coming to agreement on what would be the rules of engagement, or if you will, the rules of the road for mainly state behavior in this domain. So when I teach on the subject, I usually have a timeline, a historical timeline, where it's easy for my students to kind of look back in time. Some of them, they're quite young, so they might not have been around at the beginning of these discussions. But I usually start with, in 1998, with a resolution that was proposed at the UN Security Council by Russia. It was the first time, and I remember at that time I was working in CIA's General Counsel's office, and I remember when it came out, when the proposal came out, and what they were proposing in 1998 was for a treaty, a convention, to prohibit and outlaw cyber warfare. Right? They wanted all states to agree that cyber weapons should be prohibited. At the time, in 1998, there was little to no reaction or real discussion about this possibility. I think many Western democratic countries had recent memory that they were thinking about, that we had only been a few years previously that at least the US and a couple of our allies had come to realize with clear evidence that the Russians had been cheating on the Chemical and Biological Weapons Convention that they had signed. So I think memory was serving well at the time to think that how could we possibly verify compliance with any such of a treaty at the time. So that was 1998. And it was quiet. Any international discussions of the possibility, it quieted down after 1998. But then you saw the UN get more active, and it started around 2004. Where in the language of the UN, they don't talk about cyberspace or the cyber domain, but they use the international language of ICTs, right? International Communications Technologies. So in 2004, the UN under the Security Secretary General convened the first group of UN government experts to look at this topic of ICTs, and the thoughts and the framing of the resolution that created that first UNGG was quite broad, but it certainly didn't have anything to do with the issues of conflict, warfare, and cyber weapons. But what happened after a number of years of and by the way, the US objected to having a UNGG focused on this topic. So originally the US and others were not a fan of this. But as years passed, and particularly it was what happened in Estonia, we saw Estonia suffer from aggressive cyber operations from the Russians. And then we saw the Russian-Georgia conflict, where cyber operations were involved in a conventional warfare. So that was a critical time, 2010 timeframe, but even previous to that timeframe. The UN started with this group and continued. Now the US has been fully involved, and this is one of it's a good story and a sad story, and that Bob wanted me to emphasize is that this group has continued to meet in different sizes, starting with 15 members, now the new one will be more than 25, but the last one that was convened had 25 different countries, always with the 5 permanent members of the Security Council. 2 years they came out with no agreement, and therefore they didn't have a published report. In 2015, there was much progress. There was a published report by the UN General Assembly. All countries that were involved, 15, including US, Russia, and China, agreed that international law applied and that the UN Charter applied. 2015 comes around, they come out with another report saying that this is where we have these 3 new cyber norms that were agreed to about not targeting certs, cooperating in investigations when requested across borders after malicious activities. And then you also had, outside of the UN, you had the Xi-Obama agreement, the agreement not to conduct espionage in cyberspace in order to profit your personal, private sector, your companies, so economic espionage. So you have that agreement. That agreement was also accepted by the G20 and by a number of other countries. Whether it's being complied with or not is going to be what we discuss mostly this morning. So you have the UNGG process continuing. There was debate in 2015, even though they came to agreement on some of these new cyber norms, as to how international law would be applicable. Although they said the UN Charter does apply, the details really became important. In 2017, this is where the part of the sad story comes up. They convened again to try to negotiate over 2 years a final report. They were not able to get any agreement on further details with respect to applicability of international law. U.S. and allies were of the position that we wanted both self-defense in the UN Charter articulated in there, that states would have the right of self-defense in cyberspace. We also wanted the laws of armed conflict to be agreed to, that they were applicable in cyberspace, as well as the law of countermeasures under international law. Russia and China led the opposition positions, arguing against mentioning any of those three. For better or worse, as the size got larger of the members, new members were added, complicating the diplomatic discussions, including by Cuba. Cuba was a new member, and basically Cuba stood in line with Russia. And so they broke up without a final report in 2017. Good news to some people is that the UN has convened now a new one. There was doubt about a year ago whether this would even continue. The bad news is there's 2 tracks now going on. There's a working group, a proposal by the Russians that was accepted by the UN. This is a non-ending working group to look at the same issue of norms or rules of the road. Then the UN also approved the proposal led by the US, and that was another UNGG. That would have the same timeline of 2 years, same process. So now we have 2 tracks. Where it'll go this summer, we'll hear more about it. We have yet to hear who are the members. The UN will pick based upon geographic diversity, always with the 5 permanent members as members. So we'll have China and Russia and the US in that group. And a lot, we'll have to wait and see.
Thanks, Catherine. Angela, Brad Smith of Microsoft is probably most prominently identified with the idea that maybe we need something more than experts sitting around and coming up with norms. And he has, in a number of different forums, advocated for this concept of a digital Geneva Convention. What does he mean by this, and why does he think we need it?
Yeah, thanks. Thanks, Bob, for that. And you know, we are strongly associated with the idea of a digital Geneva Convention, but this is not kind of Microsoft's idea alone. But appreciate the opportunity to be here and share some of our thinking and participate in this conversation. And thank you to the INSA organizers for asking us to be here. So I think the first thing that's important to understand is we are calling for a digital Geneva Convention, but it is largely an analogy. Right? We're trying to make sure that the idea of making sure that there are rules of the road for behavior that can be followed to help protect cyberspace is not something that is only the expert community, right? Bob, you kind of hit on that in the top. And as Catherine went through that timeline or sequence that goes from 1998 forward, we're talking about a group at the UN, max at that time, the last one, 25 countries sitting together, deciding what those rules should be, but not actually bringing to bear the expertise of the technology community or civil society in ensuring societal values are represented inside of that process. So the idea was to help democratize the conversation about rules of the road. One of the things I think Brad has said really nicely is, in order for us to be able to make progress in this space on hard challenges, people need to understand the challenges. You even heard that in Lisa Monaco's remarks, just quoted from the Washington Post this morning. People don't understand this space. And so what the call for a digital Geneva Convention does is it helps people get some type of frame of reference to put their minds around. Not everybody has a perfect concept of what the actual Geneva Conventions are, but they have an idea. Hold on, that's about rules. And that's about rules about how you protect civilians and civilians' infrastructure. And that kind of brings a whole new set of community and stakeholders into the discourse. The other thing that calling for something like that does is it helps drive a narrative, right? We are sitting here in this room having a discourse on the Digital Geneva Convention, because we're driving a narrative that people can react to. So whether or not you agree or disagree with that particular narrative, what it does is it brings this kind of set of experts and all of you in the room to actually focus on a conversation. And we believe that having discussions like this, pros and cons, whether the analogy works or not, really helps drive progress. And what I would say before I just very briefly touch on how the proposal is similar and dissimilar to the actual Geneva Convention is that kind of process of having a panel and bringing the discourse together, we really think does have meaningful impact. So very, very briefly on similarities and differences to the actual Digital Geneva Convention. So first, in our concept, it doesn't mean that there is no existing law and there aren't any existing efforts on which to build. Whether the concept is international existing law applies, the norms that have been developed in the GGE and codified, for example, in a political way through the G7 and G20 matter. They provide a basis. But how that law applies, and if there are gaps in understanding how that law applies, is really important for us to focus on. The other thing is the Geneva Conventions were for armed conflict, right? And I think that most folks, ourselves included, recognize and appreciate that really most of the activity is going to stay below that level. This is not going to be as one expert said, the Mike Tyson knockout punch. We do see evidence of significant attacks in the ecosystem, but largely this is going to be below the level of armed conflict, kind of the sustained 12-round fights of fighters going back and forth. So we think that that's really important, that the concept of what the rules of the road should be really start to think about below the level of armed conflict. Where it is particularly similar, our proposal, to the Geneva Conventions is really in two particular areas. First, this concept that we need to think about protecting civilians and civilian infrastructure in this world of conflict. Brad Smith said this at Davos this year. He said it's really interesting. Society, it's upside down right now. Society used to think about how to protect civilians in wartime. Now we're having to think about how to protect civilians in peacetime. That's a really profound kind of thought to kind of come to bear with. The other thing that I think is really important about this concept is we believe that the progress on norms is really, really important, but these need to eventually move forward and evolve, moving past the idea of solely being voluntary, eventually moving to be politically binding, and then ultimately legally binding. This is going to take a long time, but part of the reason that we think it's important to put out a call and to push for action in this space is because the attacks are rising, the consequences are getting greater, and there is almost no enforceability. The voluntary norms, and I think we even talked about this in our prep call, the voluntary norms that have been established are largely not being followed. And so how can you start to drive progress on ensuring that they're not just rules, but those rules can be more enforceable? So, just a couple of things.
Yeah, can I just ask you to take one more minute? Yep. Because Brad Smith's proposal contains a number of specific points that he thinks should be embodied in a digital Geneva Convention. And if you could just run them down quickly.
Okay, I would love to open my phone and actually run them down, but I will try and hit some on memory. So what we have done is some of the examples that were in the specific proposal included things like not targeting critical infrastructures during peacetime, making sure that you were not attacking certs. They are largely derived from and similar to the final conclusions that came out of the GGE. There is one that is different, and that actually talks about protecting democratic processes. That was a new proposal from us. The other thing in the specifics of the proposal is they're not in UN language. Right? The UN language for each one of the norms is, if anyone has ever looked at the report, is usually something like 6 to 10 lines. And you look at it and you go, what does this actually mean? The proposals that we have are actually, again, kind of written in a language that is to be relatable. I could bring them up on my phone, Bob, if you want me to.
Well, why don't you do that and maybe we'll circle back, because I want to ask Stewart whether he thinks this is a good idea and why not.
No, and let me explain. First, I should say I like Brad Smith. I've known him a really long time. He's writing a book. He has agreed to come on the Cyber Law podcast to be interviewed about it. Maybe after he hears this panel, he won't.
He still will.
Are you guys familiar with the Cyber Law podcast? If you, I can't believe. Okay, just a few tentative hands. It's okay. Nobody's taking notes on your predilections, but it's cyber law policy you can work out to. It's ideally, and for my Democratic friends, you can go to the gym and listen to it, and your heartbeat will get to 120 without doing anything. It's great. So I do encourage you to listen to this. As for the Digital Geneva Convention, I do remember what item 1 was. Item 1 was, don't attack Microsoft or companies like us. And another one was, and we're going to sell our stuff to all you countries that are fighting with each other. Just make sure that we can keep selling our stuff to all of you. And we promise not to engage in offensive activities against you. So I have thought about whether there could be a Baker Geneva Convention. So that, and the central element would be, whatever nation states do, they can't attack Stewart Baker. And Stewart Baker should be free to sell legal services to all of them without any interference. Because this, as originally conceived, and I recognize that it is morphing, it was a kind of mashup of 80s corporate cynicism and 90s digital naivete. That is to say, we need international law that says don't attack us. Well, who wouldn't want it, right? This is a great thing. You kind of ask, well, why do we need international law for your particular business model? And then a kind of a naivete, John Perry Barlow style, your empires of meat and steel have no dominion over us. The notion that somehow the people operating in cyberspace are governed by a law that they make up and that the governments have only a modest control over. Neither of those strikes me as plausible today. The corporate cynicism, I think, is obvious and unlikely to succeed. Most people don't believe that they should be that particular companies should be free from interference. And I think the naivete is also pretty obvious when you just hear the story of how the UNGGE and the effort to create a Xi-Obama G20 set of rules about commercial cyber espionage have failed. There's a long history of failure. It is Russia's business model. It is, we'll get everybody to sign up to an international agreement and then we'll cheat. And the idea that we can write rules for cyberspace conflict that will prevent cheating or will be immune from cheating strikes me as extraordinarily naive. That doesn't mean, of course, that we can't have some agreements, but we're going to have to be enormously careful about what those agreements are and whether they're enforceable. And the idea of just invoking international law and saying we're going to move from voluntary agreement to binding international law it raises the question, well, who's going to enforce those rules? And do we think that that enforcement mechanism will act in a fashion that we consider appropriate? And I don't think there's much likelihood that that's going to happen. Last point, Brad talks a lot about the idea that tech companies should somehow be a digital Switzerland. There is, both naivete and a kind of arrogance in that, right? It's all of you pitiful nation states will fight, and we will stay in our redoubt, immune from the fight that is going on. I don't think that's likely. First, nobody believes that Microsoft is anything other than a U.S. company in the real world, except maybe Microsoft, which I don't believe is likely to prevail against the views of the rest of the world. It is naive to think that the Chinese are not trying to get Microsoft out of every computer in the country as fast as they can. It's a hard job, and it's going to take them a long time, but when they have replaced Intel chips, they are absolutely going to replace Microsoft operating systems. They don't want a U.S. company providing that service, and no amount of appeal to international law or digital Switzerland is going to solve that problem. The more likely model, and we're seeing it already, if you look at what has happened to Facebook and Google in Europe, let alone China, they're not going to be digital Switzerland, they're going to be digital Belgium. Just the country that says, hey, we're neutral, don't ooh, as the tanks go over them. So I think that's probably enough, so I'll stop there.
You'll have further opportunities. Gary, one of the problems that has hindered the development of international agreements in this area is an asymmetry between countries. Some countries have much greater vulnerability to cyber attacks. Some countries have much greater capabilities for cyber attacks, and this affects nations' willingness to limit their own ability to do things. Obviously, the United States has perhaps the greatest capabilities, cyber capabilities in the world. And understanding that you are here in your individual capacity and not speaking for the military or the government, I know that drill. How does the military think about the idea of norms or rules that would constrain its ability to use some of the most important tools that we have?
So, thank you for the invitation. Great to be here. Thank you for the preemptive disclaimer. I appreciate that as well. So yeah, these are my personal thoughts. I have spent the better part of 3 decades advising military commanders and operators on the law of war and other legal matters that impact decision-making and the ability to use capabilities and to develop capabilities. They have sought that advice consistently throughout the course of my career, not because they just like to hear me talk, but because it matters to them, right? My point being, there is, and I acknowledge the challenges in enforcement and implementation of international law, but there is absolutely, from my experience, a tempering aspect to it. It shapes how you conduct operations, and commanders are not afraid of it. Now, having said that, I think you see a cautious approach to this, which is reflective of how international law has always developed. States approach international law. They are the makers of international law, and when they find collectively that there is greater advantage to self-restraint than disadvantage, the needle moves and you can achieve consensus and agreement through treaty or customary international law on restraining principles. That is usually a reactive and a slow process for states to kind of assess and understand exactly when it is more advantageous than disadvantageous. There are lots of aspects of this technology and this domain that can provide positives in the way states interact with each other and with the way states interact with individuals. Because international law, by and large, is about states regulating their interactions amongst themselves, like inter se. The law of armed conflict is kind of an offshoot that regulates how states engage with individuals under very specified circumstances. If you take the law of armed conflict scenario, for example, you can achieve greater humanitarian ends through the use of a non-kinetic capability like cyber than you would achieving the same effect or impact with kinetic means. If I want to render ineffective an enemy's integrated air defense system, well, I have the option of launching a cruise missile and blowing it up with all the attendant damage and potential collateral impacts. Or I might be able to take a very discrete cyber action that doesn't involve those kinetic effects or risks. Now, outside of armed conflict, which I agree that is where the primary area of competition is happening, that is not regulated by the specifics of the law of armed conflict. It's regulated by the law of state responsibility and how states engage with each other. There are thresholds that are built in there that address a lot of the questions that I think have been raised, to include, for example, protecting democratic processes. The international rule that prohibits intervention in the internal affairs of another state is established, recognized. There are interpretive questions that surround it, but that protecting your democratic processes falls within the core of that, right? While there's challenges in enforcement, there's, I think, eyes wide open, we all recognize that when you have international law, there will be violators. Yeah. That shouldn't speak to not having law, right? It should speak to how you develop the law and recognize that there is going to always be a need at the international level for self-help remedies. Now, I think, one last point, I'll move on, but there's the paradox, I think, in approaching this question and looking at this proposal for the Digital Geneva Convention, is to affect your self-help remedies, you have to actually be operating in this space. This is sort of the concept of persistent engagement that the command and the department have put out. And so there's some tension there between being able to act to counter and defend yourself against the violators, and that rubbing up against some of the broader rules or norms that you might suggest blanketly across all states. So that's where you have to find that sweet spot between the humanitarian concerns, but the necessities that states have to operate, act internationally, and with their sovereign right to engage in their own self-protection.
So I'm going to throw out some issues now, and I may direct the initial question to one of the panelists, but I'd urge you all to jump in at any time with comments. I guess I'd like to start by asking Angela to respond to Stewart's thoughts about the digital Switzerland and the idea that Microsoft as a corporation incorporated under the laws of the United States and subject to the laws of the United States basically says, well, for these purposes, we're outside of the jurisdiction of the United States.
Yeah. I think this is one of those cases where it's just not true. Like, we don't think that we are beyond any nation's jurisdiction. It is in our corporate interest. Rule of law is actually in our corporate interest. This is part of how we continue to operate on a global basis. I think if you think about it a little bit, think about it more like how we want to make sure that when customers are attacked on a global basis, that those who help reduce risk and manage risk, organizations like ourselves that respond to security incidents, are not the targets of attack ourselves. It's like making sure, it's very similar to the norm on not attacking certs. The idea is that those people who are helping to manage incidents and reduce conflict should not actually be targets. We recognize and appreciate that we operate within each jurisdiction of a region that we are in. And occasionally there are cases, including here in the United States, where when law is being applied, we have actually worked to fight those particular laws. But it doesn't mean that the law does not apply to us. And it's that simple. I think the other thing, just in terms of some of Stewart's points is, you asked about, is that first norm about not attacking Microsoft? Absolutely not. And I'll read what the norm is. But, the point here is whether iCompany or any other company wants to be in this space, we are drawn into this space because our platforms and technology are the battlefield in which customers, civilians, and civilian infrastructure are being targeted. You're drawn into that discussion. And you also have an interest in understanding the consequences. Actually, Colonel Cohen I thought, did a very nice job weighing what the relative risk and the relative benefit of cyber operations are. The proposal does not say, take off the table cyber attacks. That would not be in the interest or consistent with the law of armed conflict. Sometimes those are the right tools to bring to bear to help manage proportionality and targeting and all these other things. What the norm really does say, the first two, refrain from attacking systems whose destruction would adversely impact the safety and security of private citizens, and then refrain from attacking systems whose destruction could damage the global economy or otherwise cause major global disruptions. The word that doesn't come up there that we talk about internally is indiscriminate attacks. Those attacks like WannaCry that did not actually have good tradecraft, they did not manage proportionality and targeting. That went out and had an entire public health system of a country taken offline. That's the kind of thing that you want to actually make sure is against the rules. And again, the rules will be violated, whether it's intentional or unintentional, because cyber attacks are actually hard to control. And when those rules are violated, you want to have them codified, and then you actually want to have them enforced. And so those are some of the things that I think are really important when you come to the table and think about, whether or not we are outside of jurisdiction. Absolutely not. What we're looking for is a stronger legal system that has multi-stakeholder buy-in and then can be enforced by those, which are states, that have the capabilities to do so.
Stewart, Catherine, Gary, anybody have anything to add on this? Otherwise, Catherine, I'll ask you just to pick up on the point of enforcement. One of the principal differences between sort of generalized norms and an enforceable agreement is the idea of enforcement. What are some of the problems that adhere with the idea of enforcement in the cyber area?
So there is a distinction, and not everyone identifies it, between norms and laws. Right? So when we're talking about the UNGG process, as Angela mentioned, these agreements are political agreements that are not binding as a legal matter. Now, but norms and laws both can, one, be developed in such a way for norms discussion that they're internalized and they actually can develop into customary international law. And typically, if you look historically back on the development of international law, even principles that are now codified in conventions, it took many decades for most of these conventions to actually come about, where states would actually be able to sit down and negotiate the fine words within each treaty. But before those conventions existed, for a number of these issues that became codified, they were already part of international law because they were part of what Gary mentioned as customary international law, which is just as legally binding as a treaty, but not written down. And for those that also were customary law, there's a time, if you go back further back in history, where before it became customary law, before there was a tipping point where, as customary law, as lawyers will know, international lawyers, where most states are conducting, majority of states are conducting the practice with the belief that it's obligatory legally, that's customary law. But before that point in time occurs, there is typically a norm that's developing. So this is the political scientist world of constructivism, where they have studied and talk about how norms develop between countries, how they get internalized within the country, and how it becomes a part of the culture of the country, where the country starts behaving in a certain way or not. How that happens is what we're seeing going on these days, where for the first time, I'd say in the last 5 years, we've started to see with cyber activity, operations, if you want to call them attacks. As a lawyer, I tend to be very particular in use of words. I don't use the word attack because it has a legally defined term for armed attack. So excuse my being very legally minded. But on cyber operations, we've seen a lot of countries now come out publicly. One, start attributing it to other countries, doing that collectively at times, and also not only attributing it, but then holding them accountable for behavior that they have deemed as not acceptable, even without a treaty in place. Now, some, you would argue, it's already covered by law. So whether you're conducting an operation that damages private company within a country, or messing with the elections in a country. In cyber, or if you're doing it the old-fashioned way, like by stuffing ballots, right, or funneling money into a foreign election, that still is a violation of international customary law. As Gary mentioned, the norm of non-intervention. But what we're seeing now is states are coming out, and the Attorney General, and Gary is too humble to mention his law review article on these very important issues of below the armed attack level. He discusses the principle of sovereignty. The Attorney General of the UK, I think it's been 2 years now, came out for the first time ever, any country official, came out and declared that the principle of sovereignty for the UK does not mean that you cannot conduct cyber operations which pass through another country's infrastructure without notifying that country and getting permission. That was very important. Now, that's a development of, that is how there's a development of customary norms. Norms develop because countries will act. This is part of the persistent engagement that Cyber Command has come out with. It's practice, and then it's public statements, calling a country out or not. We've called a lot of countries out recently, even with sanctions. So this is the difference between norms that can become binding law. Of course, enforcement is always, for every international lawyer, there's a million questions that are always raised. Students ask me all the time, is it really law because you don't have enforcement and states get away with violating it? It doesn't make it not law, as Carrie said, but enforcement and compliance, as most international lawyers talk about compliance, is very important. It's important for the development and the legitimacy of the law. You can also have that with the norms. How you get that enforcement varies. We're starting to see it in cyber with US sanctions against Russia, meddling with our elections, right? With their actions in Crimea and Ukraine, both cyber and physical.
And let me stop you there and just turn to Stewart here. Stewart, how effective do you think these efforts at accountability have been? That's a high-hanging curveball for you, Stewart.
Oh, give me a break, right? There is not the slightest success in enforcing any of the norms, including a direct agreement between President Obama and President Xi. And 2 years later, there's consensus that the agreement has been violated on the Chinese side. It looks more and more as though they just decided they were punishing the PLA for incompetence in getting caught and moving the task of commercial espionage over to the Ministry of State Security, which had promised to do a better job and actually is doing a better job of not getting caught. That is not enforcement of international law. So in the absence of enforcement, you kind of say, well, then why would we talk about this as law? And this is my other problem with this discussion. When you talk about what should and shouldn't be done in cyberspace as a matter of law, you trigger a whole set of activities and attitudes on the part of the United States government and the United States military, which has, in my view, unwisely tried to drive principles of international law down to the private first-class level. Everything you do in the military is governed by a set of international law norms. And that approach, which is consistent with our commitment to the rule of law, has nothing to do with the way most of the other countries that we're going to encounter in cyberspace view their activities. They're happy to sign up to these things, as I said, but they don't expect to have to comply with them. And so when we talk about setting international law rules here, we are talking about creating a asymmetric disadvantage for the United States forces. And I don't think that makes any sense at all to create rules that only the United States is going to honor as binding.
Gary?
Yeah, I'm perfectly comfortable with the notion that the private first class understands that the private first class, acting as an agent of the state, has constraints and restraints on how that private first class can operate. That's command and control. Oftentimes, commanders will issue those types of directives and orders, not just because of the law, but for mission purposes, for policy purposes, and that's called discipline in the conduct of combat. I think it's a bad hold to run down a downward spiral where you simply acknowledge that the adversary doesn't pay the same respect, and so we need to unshackle in a sense. I think we have been far better served as a military in our professionalism and in our ability to operate. And the other point is, like it or not, we're held to a different standard publicly, domestically, and internationally, and for good reason, because we've established that standard. And so when we've seen deviations and mistakes, that itself has pretty significant negative strategic impact for our ability to conduct operations, which all comes back to the question of legitimacy. Legitimacy, which is now considered an additional principle of warfare, right? In addition to the original mass maneuver, economy of force, legitimacy is one which is primarily based in like legal compliance and accountability in the conduct of your operations. So this just comes back again to how you're going to approach the question of what the value is of self-compliance and how you approach the question of enforceability and accountability. I would agree that we have made decisions as we've edged our way into this problem to try and hold other states accountable for the things they've been doing through, some would argue, tepid responses, right? That I think we've seen a strategic mindset shifting that acknowledges we need to be taking more action to counter these threats, and by doing so, sending a message of what we deem acceptable and unacceptable. Let's also acknowledge that there's a realm of offensive things that adversaries can do in the world of espionage and otherwise that don't violate international law, but that doesn't leave us remediless, and it doesn't give, we still can take measures to counter within legal frameworks, right? So I don't ascribe to that. They're not going to play by the rules, therefore we are asymmetrically hamstringing ourselves if we advocate for a rule set to apply to these operations. Now, again, having said that, what you see reflected in the UK Attorney General's position on the question of sovereignty is the reality, the acknowledgement that in order to have threat identification, tipping and queuing and warning, you're going to have to conduct espionage. States engage in espionage. In order to do that in this domain, which is a fertile domain for that type of information, you have to be operating and without the consent of system owners under certain circumstances. When that's done under public authority by a state, that's a different legal question. And that doesn't necessarily cross thresholds, right? So, I mean, we could look at the OPM breach. You can argue as to whether that, by the scope and scale that was enabled by cyber, steps outside the bounds of traditional espionage and becomes a different type of threat that crosses certain thresholds.
Don't you think that we would have done that and maybe have done that if we could?
Well, I mean, certainly that was at the time Director Clapper's exact admonishment before the Senate Armed Services Committee, right?
Can I say that's another thing that's wrong with this whole let's make up more rules even though we recognize we're the only ones who are going to obey them. You had General Clapper, after an astonishingly intrusive and dangerous theft of everybody in this room's SF-86, said, yeah, my hat's off to them. Because he couldn't find an international law principle they had violated. I don't care.
No, that's not what he said.
We still should have hit him.
Stewart, that's not what he said. That's not what he said. And he was responding to assertions by those who were questioning, but why is this not an act of war? Right? That's a fundamentally different question. And you could respond and react in that way and start launching kinetic responses because of what happened to OPM. You've opened up an entirely different can of worms. And international law would not support that. The legitimacy of that response would be infirm from the beginning, right? And so now you're going to hope for victor's justice, right? And all the consequences that can flow. But he didn't say we're remediless. He didn't say we shouldn't take measures to deal with this type of activity and this problem. And that's, again, where the UK Attorney General's position comes into play, that there is maneuver space, even within the structure of international law, to have a counter strategy here, to take more measures to prevent adversaries from being able, from source range and beyond.
And what have we done to enforce this so-called legitimacy principle that nobody else in the world seems to recognize as applying to anybody who acts in cyberspace?
I'm going to pose that as a rhetorical question, because I want to ask Angela that it sounds to me that what Gary is talking about is not at all the same thing as a digital Geneva Convention. What he's talking about is really more a sort of constrained law of the jungle. You hit us, we'll hit you so that you don't want to hit us again. What do you think about that?
So 2 or 3 things. First, we're talking about rules. Right? And I think the Digital Geneva Convention and the proposal for that is a long-term vision that ultimately the rules that I think Gary is even talking about, it's how international law applies, and that the norms that are currently voluntary or politically binding need to eventually be legally binding, such that the enforcement can have greater legitimacy. I actually don't see them as orthogonal to each other. I just see us as in different places on a spectrum of codifying the legality of these things. And I think, again, one other point on substance is the discussion of what we have proposed in the Digital Geneva Convention stays outside of the space of espionage, recognizing that that is a space that has gone on forever and will again. This is really to use Catherine's actual legal construct, about attacks, cyber attacks that are destructive in nature, really focusing on that set of activities. So I see these as just different places on a spectrum. One of the other things I did want to note is we agree that enforcement is actually really important. It's not only important that there are rules, it's important that those rules can be enforced. There are, a couple of things that I think where there's greater progress can be made. We have been very encouraged to see not only the US, but many different states engaging in attribution, talking about this particular attack was carried out by this actor. One thing that I would challenge us all to think about is how we connect that to the public discourse and policymakers' thinkings. We cannot just say X number of computers were attacked in X number of countries. I think we have to talk about what the societal and economic impacts of these attacks are, because that then helps create public will and political will for the actions that we need folks to be taking in enforcement. You've got to not only say, here's the actor who did it, it's why it matters and what part of the body of law was violated, so that you have continuity in, there was a rule, it was violated, it was done by this organization, here were the impacts, and then you can carry forward those operations. That starts to create the ecosystem of rules mattering.
Will you let me agree with Angela for a second? Because I think maybe the best thing that has happened to cybersecurity in the last 10 years is the growth of capability to do attribution and the willingness of governments to do it. That is fundamental to bringing any change to this area. If you want to enforce rules, you have to know who you're enforcing them against, and making attribution better and making it commonplace is something that I would have thought everybody up here would agree with.
Yeah. Can I just add to the legal issue?
Do that, and then I know Gary wants to, and then we'll go to questions.
I'll make it quick. So when Angela talked about a spectrum, just so I don't think we emphasize this enough, at the lower end of the spectrum, what the UNGGE process has been about is the peacetime operations, right? It has not been a discussion of war. In fact, it was explicitly carved out of any discussion that would take place within the GG members. That is why I mentioned the fact that they invoked the UN Charter and agreed to that, because the UN Charter restricting the use of force, outlawing the use of force, and legitimizing self-defense if you suffer an armed attack, that is the construct of the treaty relevant for peacetime. So they all agreed that that's applicable now. The one thing that I may disagree, and this is where I get too literal as a lawyer, on why we don't need a new specific Geneva Convention to deal with digital operations or cyber domain operations, is because we have a Geneva Convention that can be applied to cyberspace. And in fact, the US's position has been that that is applicable to cyberspace. All of the conventions, in fact. The U.S. position and Western allies, both Geneva Convention and the Hague Convention. Now, the countries that have disagreed with that are China and Russia, and those that have followed them. They've explicitly said over and over again, law of armed conflict does not apply in cyberspace. So there's certainly, what was interesting is that although Russia proposed the first treaty to prohibit cyber warfare, and they've been sticking with that story, some people say, well, the Microsoft proposal is just what Russia wants. But what's interesting is they seem to have been, just recently, letting go of that idea themselves, because now they're fully engaged on the norms discussion. Russia has chosen to give up the convention approach, focus on the norms. Well, why? Well, I think it's what the U.S. has been saying. We already have laws that apply. So I'm different than Stewart in that I strongly believe that international law benefits us strategically and has for centuries. So I think we stick with that. And if we are not a leader in proposing, like fine-tuning and filling gaps in the law, which what we should be doing and are doing in cyber, then we are not going to be the ones dictating the rules. We're going to be taking the rules that our adversaries are dictating right now. So I say you got to be in the game. And when we make international law, I express to my students, this is not a bunch of pacifists sitting around, the idealist, the Kant saying, oh, let's make some nice laws, and being naive. The U.S. has never been like that. We go into these negotiations like very savvy operators, and we're in there just like others are for our strategic self-interest.
So let me ask one of those savvy operators who's been sitting here very patiently, Gary.
I'm a lawyer, not an operator. I gave up the infantry a long time ago. So first point I think we all agree that the ability to more rapidly and accurately attribute is beneficial across the board. But interestingly, in large measure, because now you can identify and with confidence publicly accuse the perpetrator, undermining and calling into question the legitimacy of that action. Well, you have to measure legitimacy against some norm of behavior to begin with, which speaks to the development of a body of international norms and law, right? Now, I wouldn't say law of the jungle necessarily, but I kind of consistent with what Catherine noted. I look at some, and not meant to nitpick the particulars, although that's what we do as lawyers, but I see something, refrain from attacking. That in itself draws my attention, because are we talking about simply unauthorized access, which is not an attack in the sense of law of armed conflict, and it's certainly not an armed attack per se under the law that governs how states can interact with each other, but against systems whose destruction would adversely impact? Or is it don't do things that would cause significant destruction? Well, if that's the rule you're proposing, it exists, right? There are interpretive questions on the edges that are hard and raised by the nature of the capability, but causing significant destruction and physical harm to people is at least a use of force, probably an armed attack. The United States sees those two things as synonymous in international law, which would trigger the United States or whatever country's right of self-defense to go to warfare in response. So I'm not sure what that is adding to the discussion, and I think it also begins to confuse a critical point, which is The sine qua non of armed conflict and the law of armed conflict, what really separates this from states of normalcy and peacetime is that when you are in warfare, you can, let's be frank, kill people based solely on status. Not because they're coming at you with a knife, not because they're engaged in some conduct that would allow you to take self-help remedies outside of a security, a state-controlled security environment. You can kill people based purely on status. That's a huge distinction, right? But once you're into that framework, right, the Geneva Conventions don't really speak to limiting that, other than the additional protocols, if you are a signatory to the additional protocols, which brought together the two wings of law of armed conflict that Catherine alluded to, right? The Geneva Conventions are about how you treat individuals subject to your jurisdiction or power, be they POWs in the third convention, wounded and sick in the first two, or civilians in the fourth convention. That is very different than controlling the means and methods by which you conduct warfare. That's the Hague Conventions and the traditions of the Hague and the customary international law that flows from that, reflected in some aspects of the additional protocols.
So Gary, let's we have about 10 minutes left. I'd like to throw it open to questions, and I would ask, please, that people limit themselves to one question, at least until such time as everybody else has exhausted their questions.
Thank you. Sharon Tobias from Boeing. I'm curious about specifically IP theft and attacks against the private sector, and the fact that we have undeniable proof that our adversaries are doing this constantly. Do you think that while we're still debating international norms, that's going to take a long time to develop, what should we be doing today as a nation to protect the private sector and to respond to those attacks?
Who wants to take a crack at that?
So I'll offer a couple of thoughts. We should be using the full force of U.S. Sanctions, should call out and use classified information, which the sanctions regime relies on frequently, to call out, to attribute the thefts, to attribute the beneficiaries of the thefts, and to make sure that they never sell anything in the United States again, and potentially keep them out of the entire global financial system. So those are some thoughts that we can do today.
Can I just say that the ability to do that relies on international law, right? The ability for us to sanction relies on the international legal system that's been established, not all with agreement, actually. The Russians have opposed unilateral sanctions for years.
So it ain't really international law, it's just our law internationalized. I'm all for that.
Gary.
The Russians, it's universally accepted as legitimate.
It is an area not regulated by international law because of the decisions of states as to where they're willing to self-constrain or not, right? These sanctions are retorsions. They don't violate international law, and so states, in their exercise of sovereign prerogative, can use that tool. I would say there's a whole host of holistic approaches to include improving our own infrastructure. The companies out there who have brought all of this to market own responsibility for this as well, and to improve the products that they're putting out and not having them as vulnerable as they are. And I would say also that there is, this is me speaking, there is space, like sanctions, within international law for states to take actions in and through cyberspace to counter these activities, to make it harder for the others to get out of their own source range to even get to the 3 and 4 hop points into the networks where they're going to exfiltrate our intellectual property. We can protect it. And that's part of this discussion about the necessity versus the countervailing concerns about humanity and so on and so forth. And just one last point, not to understate the importance of protecting civilians. It's ingrained in what I've done for 30 years. But what we don't protect against, honestly, are all inconveniences. And that has to enter into the discussion as well. in the way states interact back and forth and the actions they take. What's protected primarily through the Hague means and methods control is death, physical injury, damage, physical damage, those sorts of things to civilians and civilian property, but not all inconveniences flowing from state engagements.
Angela, quickly, because I know there's another question.
Very, very briefly. What I think I want to highlight here is that there are roles for the makers of technology, there are roles for the users of technology, and there are roles for the government. We all have opportunities to improve in how we are each implementing our roles and how we each understand them to get the level of resiliency that helps not only with IP theft, but an overall set of things. But what I wanted to highlight here is legal remedies is one part of it, but the tech companies have things to do and our customers have things to do too. These are environments that have to be managed and change over time. Getting the roles and responsibilities between the players in the ecosystem to improve resiliency is actually something that I think we have a lot of opportunity to do to make progress in this space.
There's a question in the back there.
Hi, thank you, first of all, for not totally agreeing with each other. Lots of times panels are in violent agreement, so it's wonderful to see some really spirited, heated disagreement. My name is Manish Walther, Pori Research Strategy. One quick comment, there has been a dialogue happening with the humanitarian response community about the protection of data during conflict. One initiative is called the Do No Digital Harm Initiative. It came out of the Swiss government convening something actually with Microsoft as well, so that's something for people to look into. My question is, could we potentially look at shifting the conversation around norms instead of during conflict, but around proliferation and diffusion of these cyber capabilities? I know the GGE process is stalled, dissolved, whatever you want to say, but maybe taking an approach around export controls or something along those lines and the spread of those capabilities. I'd love to hear from you on that. Thank you.
So we just have a few minutes left, so if you're going to talk, be brief on this. Angela.
I'll let the lawyers go with the legal angle. What I would go with is I think that there are different mechanisms. There's controlling who has technology, controlling the technology itself, and controlling use of technology, right? Those are a couple of different frames of reference. What we have seen, for example, in the examples with Wassenaar is that it is almost impossible to control access to code. And so once we recognize that controlling the technology, I think at some point in time I saw hackers at Black Hat wearing a shirt that said this is export controlled shirt because they had a piece of code written on it. It's just impossible to really do that. I think that there are other mechanisms about thinking about the use of the technology and also about kind of changing the return on investment for countries deciding to invest in these capabilities themselves that are potentially more effective mechanisms. Over to the lawyers.
I think Angela's right on that, these weapons are unique in that the first time you fire them, you have engaged in proliferation. That weapon is now in the hands of your adversary and anybody else who wants to decompile it.
Yeah, I agree. 99% of the time, they're not even weapons. Okay, and the very same things, I mean, leave your username and password sitting around, and you've just enabled a cyber operation that could be, you access a system and have a whole realm of different impacts. How do you control that from a proliferation perspective? We tend to talk about this and go immediately high and right as if these are really high-end, built-up weapon systems and so on. That's generally not the case. It'd be very, very hard to control from a proliferation perspective.
3 years ago, the UN looked at this. There was a meeting in Geneva that I was involved in, and the outcome of that is every country walked away saying the proliferation issue can't be controlled, and it's got to be more about the use of it. So what are the targets that we might be able to come to agreement on that are off the table?
Question here.
Is about enforcement. You talked a little bit about that in sort of general terms, but the Geneva Convention actually has, if that's our analogy or our model, some ways to, there's like UN tribunals to be set up to investigate war crimes and things like that. To my knowledge, this hasn't been part of the GGE discussion or final declarations. So if there were to be something like that coming out of this, enforcement is important. What would it look like? How would you enforce this within a first committee context? And a second follow-up for Catherine.
One question. Okay. One question per person.
Yeah, so the reality of international law as it's developed in enforcement, there's really been very limited instances where you are having criminal accountability in enforcement, which again only applies to state actors violating generally the law of armed conflict or human rights provisions. You have to have a court that's set up with competent jurisdiction. These are all challenging questions. The UN Charter sort of envisioned a collective enforcement mechanism, which we all recognize had some built-in flaws to it with the Permanent Five and the veto power. And so that is why you see self-help remedies built in. That ultimately is really the question, but it goes to what is the legitimacy and basis for your action, which you have to have a framework to rest that upon to have a good enforcement scheme.
So one more question over here, last question.
Hi, Derek Johnson, Federal Computer Week. National and cybersecurity officials have sort of increasingly talked about the merging of government and non-government actors in cyberspace, the so-called hybrid threat. It can sometimes blur the line as to who is doing what. Attribution has gotten better, but even good attribution seems to come with a certain amount of lag time if you look at NotPetya and WannaCry. To what extent do those factors muddy the water when it comes to enforcing any potential agreement beyond the aspirational level?
So the UN, GGE, the non-state actors were not part of the negotiations. So they actually carved that out at the beginning, as well as the LOAC, the warfare aspects. So within the norms discussion, at least, they were only talking about state to state.
So I'm going to invoke, if I could, what I'm trying to popularize is Baker's law of cybersecurity, which is that our cybersecurity sucks, but so does theirs. Attribution is going to get better and better because the people who are attacking us are at least as incapable of protecting their systems as we are of protecting ours, and we're going to know more and more about them. We're going to know more about those guys, and the fact that they're running 3 shifts in China, and the 3rd shift is for their own profit instead of for the people that are paying their salaries, does not prevent us from figuring out exactly who's running those systems. And I think we're going to have much better attribution and therefore much better retribution in the future.
Yeah, we have to also be clear about what attribution we're talking about. This is not limited to cyber. The little green men that went into the Ukraine, that was an attribution question. Were those state agents, or were they operating under the direction and control of a state such that you could hold the state responsible? You can attribute to the state their actions. There's a factual piece to that is hard in cyber, but we're getting there, and it isn't limited to cyber attribution. It's all source attribution to determine that a particular actor is doing it on behalf of a state as opposed to a criminal.
And so with that, I would like to thank the panel for an extremely interesting discussion, having solved this problem. Your next one is the Israeli-Palestinian dispute, Chuck.
Thank you.
Thank you for being such a good sport.
So I think we did have a fascinating discussion here, and thank you all for that. I had one burning question that I will hold for later, though, but because you've got an audience of private sector folks here, for the most part, and we kind of touched on it back there, but we've talked about international norms, but cyber has kind of mixed public and private like we've never seen before. And it kind of gets the idea, if we talk about self-defense, we're usually talking about countries, but what is a company's right to self-defense? Okay, and that gets the issue of hacking back, but we'll hold that for another time, okay? In fact, I think we're going to put a panel together on that for our summit in September, specifically on the idea of companies hacking back, okay? So with that, thank the panel again. We're going to take a 15-minute break and be back at 11.